I'm not sure I understand exactly what you want a hearing for. If your argument is inadvertence, it doesn't seem to me that there's much you can say factually other than that. You can't say, well, this is why we did it and this is okay and all that. It's just an inadvertent mistake. Now, there obviously are a lot of legal questions to be addressed, but again, those are questions for the court, and not the basis for a factual hearing. You don't have anything. You have one sentence to say. It was inadvertent mistake.
Well, I mean, Mr. Chief Justice, I think in a case where the president's going to say that it's an inadvertent mistake is enough, and the potentially removed official is going to come in and say it was an inadvertent mistake, then you're right. I think the hearing's not going to matter that much. Now, in the real world where you have no precedent for this kind of removal, I think if there were notice and opportunity for a hearing, there might be an opportunity to not just present the factual evidence, but to also make the case. And given these particular facts about this particular inadvertent mistake, that isn't a basis for removal.
Well, I think you're talking about the legal arguments, though. The arguments we're hearing today.
I think that's right, Mr. Chief Justice, and I do think those could be made in a preliminary way in the process that was provided by the executive branch. But as I alluded to, I do think on the substantive question of what's for cause, there needs to be judicial review. And I think there needs to be judicial review of that question for all the reasons that were alluded to in the various colloquies. Because if there's no judicial review, then this is all kind of a joke. I mean, we can sit here and posit that, well, this would be for cause and that would be for cause, but none of it would matter because there'd be no judicial review.